I suppose there is something artificial about cataloging litigation into different types. Perhaps one way to think of it is you can distinguish between what are called adversary proceedings and contested matters. An adversary proceeding is a full-blown lawsuit, and it goes down the sort of path you would expect with a lawsuit. The plaintiff files a complaint, the defendant files a response, the judge will set a timetable. Within that timetable, there will be provision for a period called discovery, where each side gets to ask the other side for documentation, for information, for answers to questions. Questions are referred to as interrogatories, perhaps to depose witnesses, and eventually there's a full-blown trial. So that's a complicated process, and it tends to be rather expensive because it's very time-intensive. A contested matter is sort of an adversary proceeding light, as it were. It's not quite as involved as a full-blown adversary proceeding. Typical example of a contested matter is a claim objection. You don't, in fact, the rules don't even provide for doing an adversary proceeding as a claim objection. That's not an appropriate kind of adversary proceeding, although a claim objection can be bundled into another adversary proceeding that has other causes of action. So in that sense, we're making a distinction between less complicated contested matter, more complicated adversary proceeding. I suppose another way to catalog things is to say those types of litigation that are initiated by the debtor, and those that are initiated by a creditor, and maybe even those initiated by a governmental entity that isn't a creditor, typically the United States Trustee's Office. And why you would want to make that sort of distinction? Well, the rules are pretty much the same regardless of who the parties are. So it might be just to determine whether this is a question of assigning rights, or does it involve money? And let's be honest, generally speaking, lawsuits and contested matters ultimately at their heart involve money. So what sort of distinction is probably a bit artificial? It might not be all that important other than to make the distinction between the complicated adversary proceeding and the less complicated contested matter.